Mr. Copa, are we... Mr. Copa, are we... Yep.
Thank you, Mr. President. I have a couple of points to make in slides that I've gone by, but I thought it important to note that. If we're going to go back to slide 40 as it relates to the 2000...
I'm not sure that our slides are numbered, so you're going to have to...
Yes, the slide on the
screen.
On the screen, which deals with the 30th of April 2008 Constitutional Court decision. Is that my webcast audience calling in?
That's the webcast generally, but it seems to be on a delay, but that's fine. I'm just getting you in stereo.
Thank you very much. If you could simply, if you get there, just make a note, because we had a spirited review of this decision during the break. And if you just make a note, and the note I'd ask you to make is that there are varying readings of the 2008 decision. But all of the parties agree that the result of the decision is, as I set out, to essentially confirm the view that the terrestrial portion extends, and that therefore there's an obligation to expropriate. And it's fair that I think, in fact, that wording is wording the respondents have used at various times. There is in the reasoning of the court, and we'll deal with this in closing argument, a view that the court, in fact, did not adopt the reasoning of the typographical error, but rather gave preference to the 1991 decree over the 1995 Park Law. The end result doesn't matter for our purposes, but I just wanted to flag, since it's a very important decision of the Supreme Court, that there are varying readings of their legal reasoning. And I presented it as a fairly straightforward matter. I think it's fair to say, certainly from me as a non-Spanish speaking lawyer from the wilds of the Pacific Northwest, that I'm more dangerous than reliable in reading the decisions of the Costa Rican court, but we have people on our team who can keep me correct. The next slide, just quickly, we got a little bit off on the Monet statement. I just wanted to point out to you, and I think it's, Alex, it's slide 48 is what I was hoping for, I think. Yes, I'm just sorry. It's the, if you go back a slide, if you just look at this slide, the reason I'm pointing out is I moved a little bit too quickly through it. I said earlier in my opening that the documents are and have a number of references to the lack of financial resources, and this is just one of them, and I skipped over it. It says, it does not encourage the expansion of the park because there's a lack of financial resources to purchase lands. And that's just a reference in this opening to that. There are many other references in the pleadings, and we can marshal those in our final argument. So the next section of the slides is fairly lengthy, but I'm not going to take very long with it at all. It's essentially an attempt to draw a timeline for you in relation to the various lots in issue. And Alexandra, maybe you could do that. So this is the general timeline, if you could go to the next slide. And you'll see that those lots were purchased in 2003. Next slide. And then other lots. Maybe, Alexandra, if you could just take a couple of seconds per slide. You'll see we're moving through in respect of these. There's a decree of public interest in October 07. We were advised in the course of these proceedings that the expropriation process has been suspended. And then the next slide, the current status is title is unchanged. Now, we've also given you Appendix 2, and we've tried in a variety of ways to tell you the progress by lot of what's happened. Maybe we'll do the timeline on the Cofer lots let's do that, Alex. See, this is the general timeline. You'll see the purchase in '03. Keep going. The purchase of another lot. Just spend a couple of seconds on it, Alex. Thanks. Yeah. The decree of public interest in '07. And again, the expropriation process in these lots has been suspended, and finally the title's unchanged. Go on to the next one. These are the Spence lots. You'll see there's more of a history here. They're purchased in '05 and various other dates. There's a decree of interest in spring of 2006 for A40. Lots purchased in 2006. A decree of expropriation in April of '07. Initiation of judicial proceedings in 2007, and you'll know from the pleadings that the lots have proceeded through different, it's the same process, but there are different stages of the expropriation process within the domestic law. This lot has actually proceeded to judicial proceedings. Keep going. Decree of public interest, keep going on those lots. Another example of that, disposition dates for lot A40 in 2008. And you'll see, of course, we're in 2015, which is the main point of these timelines. Keep going. And then we have the final valuation as an example for lot A40 in 2011. And then a title transfer occurs in 2012. And the final valuation for lot SPG is 2012, after the commencement of this proceeding. Final valuation in 2013 for SPG 1. And the current status of those lots is titles unchanged. Okay, there's that. Then we go to the Berkowitz lots. Maybe Alex just flip through those for a couple of seconds each. There's a different timeline, but similar stages in the history. And you have the title transfer to that lot and title transfer for B8 in 2014. And then titles unchanged for lots B1, 5, and 6. And then Mr. Gramillion, who hasn't received a lot of attention, but we can go through his slides here. He's watching, I think, by webcast, he and his family. So this is another zombie title. So if we could then maybe go to the next slide, Alex. So the point of that slide, and of course, is the vast extent of time we're dealing with from the beginning of the controversy to the current period. And as part of our claim, of course, we say that by no account and no definition of the term can this be an expropriation without delay. Delays have been typical rather than exceptional in the history of this dispute. Now, the other feature to note was that in terms of the history, the effort to rescue the situation and to reconcile responsible development with the park was ongoing after the Supreme Court's decision. And this next slide will show that one of the bills that I talked about earlier was reintroduced, and this would have made a mixed refuge, which was a different legal designation that would have permitted development. And you'll see the note at the bottom, which is one of the commentators says, Ballestero said she agrees with the law that would find a way to obtain the land from private owners without having to use state money. And it's quoted in the article to say, we need to resolve the problem so the state doesn't have to pay for the land. I believe there are more adequate mechanisms for us to be able to make the state, to have people inside the national park. And then this is a failed proposal, but if you go to the next slide, you see in dealing with this in 2010, the proposal would have reduced the park and leave only 50 meters of beach for the leatherback turtles and allow for the construction on the beach. And then you'll know that that was unsuccessful. But as an example of the conversation about responsible development, the next slide deals with a meeting between one of the witnesses in this proceeding, Kurt Rosenko, and President Arias. And you'll see that as reflected in Mr. Rusenko's. He met with President Arias, and he says, as you say here, that a code with teeth would be needed to restrict lighting, building heights, and building density. So you couldn't have, by this man's view, 20-story buildings or 30-story buildings and the like, but you could have the kind of building that the claimants contemplated. If the 50-meter inalienable zone was respected, I thought the area could be developed with minimal impact to nesting sea turtles and their hatchlings. I also encouraged the President and his officials to engage in a national effort to keep records of sea turtle strandings, as well as a training program so they could know what nesting activity exists before they allowed further development. That's just an extract. So I'd like to go next to a broad overview, by way of opening only, of our complaints about the expropriation process. And by way of a beginning, of course, I remind you that there's a sophisticated expropriation process within the country and within the domestic law. Our complaints primarily relate to how it was implemented. There are challenges and complaints about some of the embedded means by which compensation is understated in the process, but primarily the implementation is the subject of most of our complaints. If you go over to the respect for private property in the context of a park, I've given you the reference I promised you earlier in the 1995 law, which says that the private lots of land included will be susceptible to expropriation considered part of the park until they are acquired by the state by purchase, donation, or expropriation. In the meantime, the owners will enjoy the full exercise of the attributes of domain or ownership. So the law of Costa Rica did not contemplate the suspension and freezing of property rights while the development of the park was underway. If you then go to a summary, this is my summary by way of opening of some of the characteristics of the historical record. In my submission, they can be summarized in 5 different ways of the state avoiding the taking, which has both been ongoing and is still ongoing, freezing property rights in the meantime, deferring obligations to compensate, deferring payment of compensation, and minimizing compensation. I'll just give you some examples of each of those. The next slide deals with the first. And the most obvious point is today, the respondent has only directly taken 3 out of 28 of the claimant's lots. And I think that fact can't be more, there can be no more persuasive fact of the fact that the state has avoided the taking than that fact. And that delay flies in the face of the decision requiring expropriations to be conducted immediately. The next is the freezing of property rights. And of course, you have a small but telling example. In Mr. Berkowitz's home, he presented an environmental impact assessment which demonstrated that his home would not adversely impact the environment and would be a responsible development. As he testifies in his witness statement, the agency receiving that purported to lose his application, and then we find out later that there was a suspension on the approval and review of environmental impact assessments, and then later, at some point, a permanent suspension, unknown to the claimants, but effectuated within the government. The next approach is that of freezing property rights, and the fundamental one I mentioned earlier is essentially preventing environmental assessments, basically saying you can do any number of environmental assessments which show that development is fine. We don't care. We're not going to review them. We're not going to proceed any further at this point, but without actually expropriating and taking the property and compensating for it. And the next slide just points out that in the meantime, there are obligations. The owners are required to pay taxes, required to maintain the properties. The next slide deals with deferring the obligation to compensate. And the points that to me made there is for those lots which are in the judicial phase, it says a slow pace to judgment. I think you might put glacial rather than slow there. For the lots which are in the administrative phase, as I pointed out just a few minutes ago, there's been essentially an indefinite suspension of the expropriation process to avoid triggering the obligation to deposit the administrative appraisal. That's our inference, that essentially faced with the fact that you have to deposit some money, the government officials froze the process before that obligation came into being. And we say the inference can be drawn that that's indeed the case, because at the time of the initial freeze, there was an administrative appraisals which had been actually higher than previous appraisals. There was no report recommending a suspension. The suspension happened, and then the report came out very shortly afterwards. So we say that's telling evidence that in this context, the officials were seeking to defer the obligation to compensate. Next example is just as a concrete example of delay for Lot A40. This is only one of the lots, but you have a decree of public interest in 2006, 9 years ago. You have an administrative appraisal in 2006, some months later. You have judicial proceedings in 2007, and we'll deal in detail in our closing with who's in control of which stage of those proceedings. You have a judgment in 2010. The payment is received in 2012 of principal. The payment of interest is not received until 2015. The next point, of course, is in respect of the deferring of payment. The system is susceptible to permitting delay, and we've identified two examples here between the determination of value and the actual deposit of that amount, and we've seen that, and between the deposit into the court account and payment to the owner. Now, the final tool that I'm, by way of theme, identifying for you that we see in the evidence is a variety of tactics to minimize the compensation. And I won't get into all the detail here, but just a couple of examples by way of highlighting is you'll see some of the valuations based on conservation as the highest and best use of the land. Of course, if you can treat the land as already parked land and unable to be used for its highest and best use, you can then dictate a minimal value to the land. The other outstanding recommendation, one of the outstanding recommendations of the Contraloria report, was the direction to annul titles, that is, to pursue the annulment of property titles, which of course would by necessity then eliminate the obligation to pay compensation to the registered owner. So in summary, we think a fair reading of the history suggests that faced with an unwanted and undesirable obligation to compensate, the state has had recourse to every imaginatively available technique to either avoid the taking, defer compensation, or otherwise, as I've said, minimize the financial consequences of their obligation to take the property and compensate for it. The next slide goes into valuations, and we can go fairly quickly through this, but these are illustratives of the differences in valuation. So if I can deal with Lot V30, you'll see just by way of a bar graph the dramatic difference between the administrative appraisal in this situation and the claimant's independent valuation. For Lot V31, similar discrepancy. We don't have judgments in these cases. For Lot V32, again.
Can I just ask, sorry, no, I've got that.
These are all expressed as in colonies is the number at the top, and then we have US dollars within the box, I believe, and price per meter. Lot V33, similarly, just by way of illustration. Lot V38, Lot V39, Lot V40, Lot V46, Lot V47, and then we have with Lot A40 a lot which has gone through more process, and you'll see, interestingly enough, there the administrative appraisal on the left, the FTI evaluation, you have the judgment, and then you have the judgment on appeal. So if you ignore the FTI appraisal, you'll see the dramatic difference in valuations even within the internal process. If you go to SPG 1, there's a similar dramatic difference between the value attributed by FTI, but also the value between the administrative appraisal and, in this case, the judgment. In SPG 2, you'll see a dramatic variation both with respect to the internal valuations and with respect to the FTI evaluation. If you go to Lot B1, you'll see the dramatic difference between the administrative appraisal and the FTI valuation. Lot B3, in that case, there's a judgment applicable to that lot. Lot B5, Lot B6, and I think we can just flip, those are the only two lots left, B7, and then B8 you have another example where there's a dramatic discrepancy between the administrative appraisal, the judgment on appeal, and the FTI valuation. So, of course, in closing, we'll deal with each of the lots in detail, and we'll deal with the expert evidence on damages. I'm going to have a few comments on the damages issue by way of opening, but that, of course, awaits the cross-examination of the experts on their reports later in the week. I'm just checking my time. So I'm going to turn to a different topic, and I'm well within my 2 hours. I probably will finish a bit early. But I want to spend a few minutes on the legal side of this by way of opening only. And I said some of this in the introduction to the whole case, but if we could go to the slide, Alex. And I did say in the introduction that in our view, this is calling upon the respondent state to honor what we submit to you as a core promise that is made to foreign investors under customary international law and CAFTA. And I think it's useful to reflect on what that promise is. The promise is not that we will not take your land. It is that we will take your land in accordance with acceptable principles. We'll take it for the right purpose, and when we take it, we'll compensate you, and we'll compensate you in accordance with fair market value, and we'll do so without delay. And in this case, from a legal question, we don't have to worry about, some of these cases deal with unusual types of property. We don't have to, this is back to dirt law. In Canada, we would call it dirt law. This is compensation for land that has been taken. So there's no question about that. Similarly, if you look at the entire pleadings, there's no practical question now that Costa Rica has determined to expropriate all, or at least the most valuable portion of each of the claimant's titles. And as I said in my introduction, we're not disputing the outcome of the political and legal debate within Costa Rica, however you interpret that. That's not the purpose of this hearing. But in our submission, what the history reflects and demonstrates abundantly is that the respondent has renounced its obligations under international law and CAFTA, and that renunciation is ongoing to the present day. And indeed, at present, the respondent remains unwilling to inform even this tribunal when it will finish the recommendations it says remain to be outstanding in 2015, arising from the Contraloria report in 2010. Now, fundamentally, that's what this case is about. As you know, and my friend will deal in reply with the timing issues which have been raised by the respondent. For that purpose and other purposes, I would comment quickly on the FET claim, which is both additive and alternative in the present case. And that is the Article 10.5 of the treaty. And if we have that slide in front of you, and I'll leave the detail and the scholarship of this to Dr. Weiler. But fundamentally, of course, the fair and equitable treatment obligation has similar historical origins to the obligation to compensate for expropriation. And there's a broad consensus in my submission of, oh, hold a second, this is remaining, this wasn't fixed at night. Okay, so this was this slide says fair and equitable treatment, but that's expropriation. So you need, I saw this typo last night, but it wasn't caught. So if you make a note, the second slide, the first slide says core promise, and the second one is not FET, but is in relation to 10.7. So that is a typo with respect to the title and the reference to 10.5. FET is 10.5. So that was a typo we didn't get in this version. I'm sorry for that. So, and I've covered the areas of reliance in 10.7. So with respect to, if you go to what's in your slide, the second fair and equitable treatment slide, but it's really the only one we put in as part of the opening. The CAFTA parties have deemed FET to include denials of justice. I note that. And that, of course, applies to both executive and judicial branches of the state. The legitimate expectations doctrine, which we've directed, is relevant to the application of an FET analysis. In addition to expropriation standards, they are additive in that sense. And abuse of right is another well-established international law doctrine that can help in applying the FET standard. And in this particular case, FET claims arise with particular force because of the arbitrary manner in which the respondent has imposed and maintained new delay measures, we say without even notifying the claimants, that the claimants detrimentally relied on the explicit terms of Costa Rican laws, the conduct and representations of Costa Rican officials, and indeed in one case the representations of the Environment Minister himself. Thirdly, the arbitrary nature of the expropriation regime, which I indicated earlier, has inconsistent standards and offers an abuse of the right of property owners to fair market compensation. And of course, we say that the inadequacy of that regime amounts to a de facto denial of justice under the FET standard. So the final comment is on damages. And in our submission, you will be satisfied at the end of the analysis that this case primarily concerns the question of what is the appropriate amount of the award, rather than whether or not there should be award. And I had said that earlier in our pre-hearing submissions. That, of course, is a point on which my friend vigorously disagrees, but it remains my point. So in relation to the damages, we've submitted a real property appraisal report which values the subject lots with an effective date of value of May 27th, 2008. And our appraisal report was prepared by an accredited and licensed appraiser in conformity with the uniform standards of appraisal practice and the Code of Professional Ethics and Standards. Now, and this is not getting into the detail of lots or comparables or otherwise, but the point is that the appraisal report, if you go to the next slide, determines fair market value in the manner specified and in accordance with customary standards in Article 10.7 sub 2. And then it concludes that the aggregate value of the takings is $36.5 million, or the equivalent in colones, and you'll recall that we've claimed the award in colones, plus interest and costs. But in relation to damages, let me just make this observation by way of opening. You do not have to select between appraisal reports in this case, because there is only one appraisal report. And of course, you'll want to be satisfied that appraisal report is properly and appropriately prepared, but the respondent has not presented you with an appraisal report. Rather, they filed a report from a valuation expert who's not an appraiser, and his fundamental report is, if I may put this way, an appeal to you to apply a different measure of damages, being the purchase price of the claimants for their lots. And our fundamental answer to that is actually not a factual answer, it's a legal answer, which is that's not the standard which you're required by law to apply. That's not open to you to apply. It is not an appropriate standard in an expropriation case. It's not an proper standard in any evaluation in this context. And so I note that because it's an unusual thing in a case of this complexity to have only one appraisal report. and in my submission on behalf of the claimants, that's a telling observation. Doesn't mean we abandon our attention at that point, but you'll see that that is very much the approach we take to the conflict on the factual question of the damages to be drawn in this case. And of course, we claim pre- and post-award interest and costs. Okay, I think we'll conclude my opening at that point, Mr. President, members of the tribunal. And as I said, we reserve 30 minutes for our reply, but I think I've finished before my time. But that's maybe a good trend to start the week with.
So you've got no other co-counsel who are going to be presenting in your opening at this stage?
Not directly, no.
Okay. Thank you very much, Mr. Alexandrov.
Mr. President, just one procedural point, if I may. Council went through about 100 slides very quickly. Those are demonstratives, and under the instructions of the tribunal, they are to be used in the context of the opening statement. So we reserve the right to, this is not a written submission, so we reserve the right to object to some demonstratives, so-called demonstrative that weren't actually used in the opening statement. I just want to make a reservation of rights right away.
Okay, thank you. Let me just take a moment with my colleagues to see if there are any points of clarification that they would like to raise at this point. I think, Mr. Coper, you have got us off to a speedy start. I think we can adjourn now. We have on the schedule an hour and a half for the break. I suggest that we come back at the hour and a half rather than at the allocated time, which was 2:30. If you're both content with that. So if we break now, I'm looking at that clock, which is just before 22. If we said 2:10, would that suit both sides? Yes,
that's fine.
Let's break then, and we'll reconvene at 2:10. Thank you very much.